Have you ever had a client give you a call once they're under contract and they say, hey, I just got this package from the title company and they're asking me how I want to title my property? If you're a real estate agent and that call comes into you, there's a few things you want to know. Patrick MacQueen is here with us again today. Patrick, thanks so much for coming in.
Yeah, my pleasure. Happy to be here.
So today we're going to really dive deep into the whole proper titling of residential real estate. And I think that, when a home loan's being used, there's a sequence, but whether a home loan's being used or not, the title company is generally the entity that is communicating with the buyer and giving them some direction, but certainly they're not giving legal advice. And as a real estate attorney, I know that you were telling me you had a scenario where the real estate attorney actually gave the wrong advice and it caused some issues. So let's dive in. What you got?
Yeah, so there was actually a recent case that came out in the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals covers us here in Arizona. It covers parts of California, covers us here in Arizona as well. And it was a bankruptcy case. And the couple, the married couple, in connection with this bankruptcy case, they were trying to save one of their homes. They didn't want it to go through the bankruptcy process. They didn't think it should. And their whole argument was, well, we thought we titled our property in one way, but ultimately it was something much, much different. Okay. And so the gist of this case, the court came out and said, if you are a married couple and you live in a community property state, like Arizona, like California, like about 8 other states, then it is presumed that when you purchase real estate with your spouse, it is going to be a community asset. It is presumed, it's almost automatic that unless you do something else, it's a community property asset, and you're taking title as community property with right of survivorship. Okay, and that particular instance, there was some advice that was given. And the real estate agent basically said, well, this is the way that everybody takes title, therefore you should do it here as well. But that advice was apparently inconsistent with what these folks ultimately wanted to articulate to the bankruptcy court, et cetera. And so as a real estate agent, we really shouldn't be giving out that type of advice on the way in which title should be taken. Now, you can always fix a title issue until you can't, until there's a bankruptcy, until somebody dies, until there's a divorce, then you're stuck. And so you really got to take care of these title issues pretty quickly if there is one. There are many, many, many reasons why a married couple may not want to take title as a community asset, as community property. One of them may have more assets than the other. One of them may have had a bankruptcy. One of them may be concerned about inheritance issues. So there are many reasons why a married couple may not want to take title as a community asset. And so in this particular instance, when they did take it as a community asset, it came back to bite them.
So what are the options? Let's just kind of walk through the average home buyer today. I know you've got a chart that you're going to share, and I so appreciate it. We'll push that out for sure. But we are very cognizant of the fact that we can't give legal advice, but we certainly do want to educate our buyers and help them navigate their particular scenario and where they might fit on those options. But kind of walk us through some of the most common, I would guess, and then maybe pros and cons to each.
Yeah, so people can take title in about 4 or 5 different ways, at least here in Arizona. You can take it as community property, and that's generally what most married couples want. They want it that way. You can take it in your sole and separate capacity. I take my property as in my sole and separate name, separate and apart from my wife. There are different reasons you may want to do that. You can take it as a joint tenant with someone else. You can take it as a tenant in common. That's what we usually see when there are investors. There are multiple parties that are going to own real estate. You can take it in the name of a trust. You can take it in the name of an LLC. And the reasons behind taking title in different ways all really boil down to, who do we want to have this property when I pass away? How am I trying to protect this as an asset? And what potentially are the tax implications? And so there's really 3 or 4 kind of big picture items that people need to consider. Taxes, maybe. Inheritance, certainly. Asset protection, and maybe some management of the property as to why you would take it in an LLC or a trust versus as a joint tenant with right of survivorship. If I want to go in on a business deal with a buddy of mine, I'm probably not going to take it as a joint tenant with right of survivorship, because if I pass away, all of my interest automatically upon my death goes to him. Well, maybe I want my family to have that. Maybe I want somebody else to have that. And so it really depends on what it is you want. Again, this came out of the situation where it was a married couple. Everybody thought they wanted it one way. They ultimately didn't. Maybe they did, maybe they didn't, who knows? But ultimately, this was a big time clarification of community property. And the courts are basically saying, if you're in a community property state, it's going to be deemed community property unless you check the box with the title company and take it in a different manner, or you change it down the road.
So can we kind of walk through joint tenants with right of survivorship and then community property with right of survivorship? Because those are the ones I see most often. And I see it with married couples. Like, why would a married couple do one versus the other? I know you mentioned if they have a bankruptcy or something else, but is there just something else that I'm missing? Or is it just that they're just like, they don't know, so they're just picking a box on the chart when the title company reaches out?
Yeah, that's funny. Most people don't know, and they do just check the box. And there's not a huge distinction, but it's basically on an inheritance. If you want there to be some other person that perhaps inherits it, then you don't want the right of survivorship. You want it as a community property asset, but you don't want the right of survivorship to attach. So that's a small distinction that we have here in Arizona. Most states don't actually have that further distinction, but we do have it here. And so again, it really depends on how, whether you're coming, is this your second marriage? Is this your third marriage? Is this your first marriage? Is there somebody else down the road that I want to have this as opposed to my existing spouse? So that's why we have that small distinction here in Arizona. Most states don't have that, but again, it's really about what the parties want, and it's articulating that before there's a death, before there's a bankruptcy, before there's an asset issue, before there's an inheritance, before there's a problem. And so it's very, very easy to correct title. It's normally a matter of a new deed or two, depending on how you've got it titled. So it's actually a fairly simple fix as long as everybody signs, and as long as everybody signs in time.
So you mentioned this whole married with sole and separate property. I've had other, divorce attorneys, they kind of are downstream in that type of scenario. And in a community property state, there's some discussion about after that may be executed, and let's say that relationship has been together now for 10 years and Arizona is a community property state. I've seen some types of discussions like, well, it doesn't mean that there's not any true, I wouldn't call it interest in the property, but certainly when it comes to separating assets and things like that, there's like, I always thought it was like clear cut, well, I guess the law isn't clear cut, but it's like you sign the sole and separate, boom, that's his house. You have no interest in it, but I'm learning that's not necessarily the case. Can you give us a little, flavor on that one?
Well, for lawyers, there's always a gray area, and some lawyers are always going to try to push the issue. And what you're talking about is a situation in which, let's say, I grant my home to my wife, and so what I'm going to do is give her a deed, and it's going to be her sole and separate property. And then what I also have to sign, this is important, is a disclaimer deed. Okay, and I have to give her the property, and then I also have to disclaim my interest in the property. That's kind of a two-step process when somebody's getting sole and separate property, because you want to make sure both of those happen. But what you're talking about is a situation I think you're talking about, because I don't practice in divorce law, but this is what
disclaimer there, Patrick. But go ahead.
Yes, big disclaimer. Fortunately, I'm not. I can only handle one subject area, and that's real estate. But what you're talking about is this commingling issue. If we've been married for so long, if we've commingled every single other asset, well, maybe there's an argument that we also now share joint interest in this property, even though I conveyed it to you, even though I disclaimed my interest. guess what? We're starting to trickle into, well, we've got so many joint bank accounts together, and we've just mixed everything together, and so now, guess what? Your property is actually mine again. So
Yeah.
I think that's what you're getting into. It doesn't happen all the time, but you get it. You get somebody who really wants to push the issue, and that creates a little bit of doubt, and that creates some settlement leverage when you do have one of these divorces, or when you do have somebody pushing this issue. It happens in unmarried couples as well. We see it in the unmarried couples. Because when we have to break apart a relation, well, we don't break apart the relationship. We're sort of the scavengers that come in and rip it apart, but we don't break it apart. We don't start the process. When a couple decides that they're no longer going to be together, an unmarried couple, what we do is we do a partition. Okay, we can't physically split a property in half and sell it that way. So we have to do what's called a partition, because of the way in which people titled their assets. Most people are titling their assets as boyfriend and girlfriend, as joint tenants with the right of survivorship. Guess what? The only way to break that up is to have a partition. If the couple had gone and created an agreement that says, this is what's going to happen if we decide to break up, well, then guess what? That's going to be enforceable, and we wouldn't have to do the partition. But most people, again, they only see the positive, they only see the upside. They don't realize something bad could happen. And so they don't realize that they could retitle this and save themselves a lot of trouble. And then we end up having to come in and partition.
That is such good information, honestly, because we're seeing so many more people buy together that aren't married. They're just friends or whatever. But because of that, I think that what you just said is key. So having them reach out to you and just have an agreement prepared for the what if, right? So what if one of us decides that we don't want to be in this partnership or relationship anymore, then here's what happens. That's huge. Oh my gosh, thank you so much for sharing that. I do want to let you know that from a home lender standpoint, I think that there's a misconception out there. So from our standpoint, let's say we have a husband and a wife and one party can't be on the home loan because of credit. So in that scenario, I always really want to talk with them and like, is this, is something happening in the relationship? Is this not happening? Like you guys are good, together in the relationship, because a lot of people don't realize that even though the person's not on a home loan, they still can be on the deed of trust, which means that they would still need to be on the purchase contract because they're essentially purchasing the property together. And so we'll make a note of that and make sure that's noted on the pre-qualification form that, Patrick and Amy are purchasing the house, but only Amy's going to be on the home loan type of thing. Both will be on the deed of trust. And I think from that perspective too, I'm always making the point to make sure that they understand that the person that's on the home loan has the sole obligation for the home loan, even though there's multiple parties, involved on the ownership. Because again, like, oh, cool, I own the house now, but I'm not legally obligated on the note. So I think that there's a lot of stuff there, but I still hear today, oh no, he has to disclaim because he can't be on the home loan. No, that's not necessarily the case on the type of the home loan that they're obtaining.
There is a huge misunderstanding about being on a loan and being a participant in signing a note and being on title. One does not always equate to the other, and that's exactly what you're pointing out. And there is so much confusion on that. People think, well, I'm not part of this anymore. I don't have to do anything. Or I am part of this because I'm on this document, but not on this document. And so it's really getting those questions answered ahead of time. And for me, again, it's if we're going to go into some sort of venture together, whether we're contemplating marriage, whether we're already married or whatever, let's make sure this works for both of us now and in the future. And if we need to come up with an agreement to make that happen, great. If we just need to retitle these assets, that's fine too. But you got to consider it instead of just checking the box and saying, well, this is what my agent told me to do. I don't know. You got to be a little more careful.
The other thing too is if you have a married couple that they both go on the deed of trust, they were both on the home loan, and then they go through a divorce, the divorce decree will say, okay, this person's going to keep the house. What people don't realize is even though they disclaim their interest, unless that home loan is refinanced into the party that's going to retain the home, it doesn't matter in the bank's eyes. You're still both legally obligated on the note, and now you just disclaimed your interest. So I'm always like, hey, if you're gonna go through a divorce, you make sure that that divorce decree has some type of verbiage in it that requires that the person that's going to stay in the home refinance that mortgage into their name only. That's the only clear way that you can truly be out of the woods, because if they go late, it's gonna impact your credit score. It doesn't matter, you sign a disclaimer deed. So many people don't realize that.
I know, it's crazy. And you need to have a time frame for getting the refinance done too, because if it's open-ended, somebody's going to sit there and do nothing for as long as they can. And so, yeah, it's
a straight market, right? Like, so like, I don't feel like it. No, I can't. My rate's going to go up by 1% or whatever. So
yeah, it'll make a huge difference.
Well, if you have questions, please reach out to Patrick. He's amazing. I've known him for many, many years, and he's my go-to source when it comes down to real estate related questions. Patrick, thank you so much for joining me today.
Yeah, my pleasure. It's always fun.